In today's seminar, we're going to be looking at human rights during emergency situations and terrorism. At the end of this seminar, you should be able to identify and apply the key features of derogation clauses in international human rights law. You should be able to define what a state of emergency is, and recognize the links of states of emergency and terrorism, and the risks posed by entrenched emergencies. You should also be able to identify non-derogable rights in international human rights law treaties. So to begin, what is a derogation? Well, a derogation is an exemption or relaxation of a rule of law. In the context of human rights law, it means that a certain right will not be protected in the normal way by a state. Derogations from human rights protections should be temporary and in response to emergency situations. Now, many international human rights law treaties contain derogation clauses which allow states to create exceptions to human rights protections in specific situations. The International Covenant on Civil and Political Rights contains a derogation clause in Article 4. The European Convention on Human Rights contains a derogation clause in Article 15. And the American Convention on Human Rights contains a derogation clause in Article 27. Now, states may not always need to derogate from a human rights law treaty in order to introduce emergency provisions. Many rights are drafted in such a way as to allow restrictions on them without the need for a full derogation. So, for example, qualified rights, like the right to freedom of association, allow states to lift or to limit assemblies in the interests of national security or public safety, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. Once these measures are prescribed by law and proportionate, they are permitted under international human rights law. Now, when we look at the key features of derogation clauses in international human rights law, there are a number of features which are common to each of the derogation clauses in human rights law treaties, like the ICCPR and the European Convention on Human Rights. In the first instance, it requires that there must be a war or public emergency, that the war or public emergency must threaten the life of the nation, that the measures taken in response to the situation by the state must be strictly required by the exigencies of the situation, and that the measures taken must be consistent with the state's other obligations under international law. The measures must also be notified to the relevant body, so in the case of the International Covenant on Civil and Political Rights, this would be the UN Secretary General. Similarly, in respect of the Council of Europe and the Organization of American States, in respect of the European Convention on Human Rights and the American Convention on Human Rights, respectively. Now, finally, the last commonality is the derogation clauses contain lists of rights which are considered to be non-derogable. So starting with the first feature, there must be a war or other public emergency. So what is a war in this context? What does it mean? Well, the use of the term war in this context is slightly ambiguous. At the time that the Article 15 of the European Convention was drafted, which served as the basis for many other derogation clauses in other international human rights law treaties, in the late 1940s, war would have been understood as an international armed conflict between states. Regulations of non-international armed conflicts, or civil wars as they're commonly known, at the international level was very limited when the European Convention was actually drafted. Now, this changed with the later adoption of additional protocols to the Geneva Conventions, particularly Additional Protocol 2. And since Article 15 was drafted, the differences in legal regulation of non-international armed conflicts and international armed conflicts has gradually faded, particularly under the influence of customary international law. So we could now argue that the war referred to in Article 15 should cover both international and non-international armed conflicts. Now, the next issue is how we define what a public emergency is. Oren Gross defines an emergency as a sudden, urgent, usually unforeseen event or situation that requires immediate action, often without time for prior reflection and consideration. In the case of Lawless versus Ireland, the European Court of Human Rights stated that a public emergency threatening the life of the nation should be understood as an exceptional situation of crisis or emergency which affects the whole population and constitutes a threat to the organized life of the community of which the state is composed. Now, the key word here is exceptional. The state of emergency and normality should be mutually exclusive. This is a situation in which the state considers the normal rules of international human rights law cannot be applied. And this is echoed in the Greek case, where the European Court of Human Rights states, "The crisis or danger must be exceptional in that the normal measures or restrictions permitted by the Convention for the maintenance of public safety, health, and order are plainly inadequate." Now, the next issue to discuss is what is meant by a threat to the nation. As a general rule, there needs to be a threat to the state's physical population, its territorial integrity, or the functioning of the state's organs. Now, states have been given a lot of leeway in determining the existence of this threat in practice. In the case of Ireland versus the UK, for example, the European Court of Human Rights stated that by reason of their direct and continuous contact with the pressing needs of the moment, the national authorities are in principle in a better position than the international judge to decide both on the presence of such an emergency and on the nature and scope of derogations necessary to avert it. In essence, this means that the international body will often defer to the assessment of the domestic body as a matter of course, allowing them a margin of appreciation to determine the existence of the threat and the measures that they need to take to counteract it. Now, we'll discuss the margin of appreciation in more detail later, but ultimately it means that the courts tend not to scrutinize the underlying reasons very closely in these cases. If we look at the UK as an example, it had a derogation from the right to liberty and security in place in Northern Ireland for 27 years because of the threat of terrorist attacks from the IRA. When one considers derogations are supposed to be exceptional and temporary, the fact that it was in place without change for so long clearly calls this into question. Indeed, it was challenged in the case of Marshall versus the UK. When that case was brought, the security situation in Northern Ireland had drastically improved. A ceasefire had been in place for a long time, and the Good Friday Peace Agreement was on the verge of being completed. The emergency, at this point, seemed to have clearly abated. But nonetheless, the European Court of Human Rights considered the margin of appreciation should apply to its assessment, and that the national authorities were better placed than the international judge to decide both on the presence of such an emergency and on the nature and scope of the derogation necessary to avoid it. Now, Nealien and Gross argue that this approach of deferring to domestic authorities is breaching the court's duty to assess these complex and sensitive cases. But at the same time, you can see some logic in the court's approach, because they would obviously want to avoid second-guessing a domestic authority on an issue of national security. The other dimension we should examine is whether the threat must be to the entire nation or whether it is sufficient that a part of the nation, perhaps a province or a region, is threatened. Again, this threat has to be interpreted liberally. Bergenthal notes that a public emergency need not engulf or threaten to engulf an entire nation before it can be said to threaten the life of the nation. And we have seen geographically limited derogations in the past, such as derogations by the UK limited to Northern Ireland, and derogations in Turkey limited to the southeast of that country. Now, in many cases, states use derogations in response to terrorist threats. There is a very strong link between terrorism and the use of derogations. It is a recurring issue. We have seen Turkey derogate in response to a terrorist threat from the PKK, France derogate from the recent terrorist attacks there, and the UK derogating in response to terrorist activities of the Irish Republican Army and later Islamic terrorist groups. And the link between establishing states of emergency and terrorism is very clear. Now, we're going to be referring to the case of A and others versus the UK quite a bit in this seminar, so it's worth introducing the case properly. The background to the case is as follows. The terrorist group called Al-Qaeda committed a series of terrorist attacks on the 11th of September 2001, including crashing 2 planes into the World Trade Center in New York. As a result of the attacks, many states introduced measures aimed at tackling extremist Islamic terrorist groups. The UK, supposedly because of its close alliance with the USA, decided that it was necessary to introduce emergency measures to combat the threat posed by Islamic terrorists. As a result, the UK derogated from Article 5 of the European Convention on Human Rights. This is the right to liberty and security, in order to introduce a particular piece of legislation aimed at tackling the terrorist groups. The legislation was called the Anti-Terrorism Crime and Security Act of 2001. Now, under this legislation, where a specific government minister, the Home Secretary, reasonably suspected that a person's presence in the UK was a risk to national security and suspected the person was a terrorist, that person could be detained indefinitely. Now, the crucial thing to note about these measures is that they were only directed at foreign people. They could not be applied to UK nationals. The reasoning behind these measures links back to the principle of non refoulement. A brief explanation of the principle might be useful here. So there is a principle in international human rights law, the non refoulement principle, which says that a state may not expel someone to another jurisdiction where they face a real risk of being subjected to torture, inhuman, or degrading treatment in the other jurisdiction. We saw in the case of Chahal versus the UK, for example, that this principle prevented the UK from expelling Chahal to India because he was at risk of being subjected to torture in the receiving jurisdiction. Now, the issue in this case is that the non-refoulement principle prevented the UK from expelling many of the people they suspected of being terrorists from the UK, because if they sent them back to their home countries, it was likely they would be captured by the security services and subjected to ill treatment. The UK's solution to not being able to send them back was through this legislation. And under the law, the suspected terrorists could either stay in prison indefinitely, or they could leave to another country where they would not be at risk of torture. Now, why is this case important in the context of derogations? Well, in the A and others case, the applicants challenged the need for the derogation. They claimed that to justify a derogation, international terrorism had to threaten our institutions of government or our existence as a civil community and go beyond a threat of serious physical damage and loss of life. In response, the European Court of Human Rights again granted the states a wide margin of discretion to determine whether the derogation was necessary. They stated, the court has, in previous cases, been prepared to take into account a much broader range of factors in determining the nature and degree of the actual or imminent threat to the nation, and has in the past concluded that emergency situations have existed even though the institutions of the state did not appear to be imperiled to the extent set out. So again, a great deal of flexibility is offered to the states to determine both the existence of a threat and how to respond to it. A key issue with the use of emergency powers is the tendency for these situations to become quasi-permanent and to continue over time and become what are often called entrenched emergencies. So for example, Syria had declared a state of emergency from 1963 through to 2011, while Egypt declared a state of emergency from 1981 through 2012. In each case, the states used these emergency situations as a justification for introducing very repressive conditions on their people. But the phenomenon is not limited to a few countries in the Middle East. It is observable all over the world. Even in Europe, we can see this phenomenon of utilizing emergency powers over protracted periods of time is clearly reflected in the data on derogations from the European Convention on Human Rights. Now, the longest derogation made from the Convention was the UK's first derogation in Northern Ireland, which from the official notification of the derogation to its termination ran for 9,918 days, over 27 years in total. Now that figure increases when one considers that emergency powers were first implemented by the United Kingdom in Northern Ireland on the 16th of June 1954. If the derogation commenced at that point, and the derogation is unclear as to whether it has retroactive effect, its duration would run for 11,025 days, or over 30 years in total. As Gross notes, emergency has not been the exception in Northern Ireland, it has been the norm. Now, the derogation in Northern Ireland is not an isolated example. The data shows that the average duration of a derogation from official notification to termination was 1,389 days, or almost 4 years. If one counts from the first adoption of the emergency measures to the final conclusion, that figure rises further to an average of 1,726 days, which is closer to 5 years. This is a long time to have in place temporary measures aimed at addressing an emergency situation. Now, the European Court of Human Rights, for its part, has been surprisingly unconcerned by the issue of the duration of emergencies. Again, in the case of A and Others versus the UK, the court stated that while the United Nations Human Rights Committee has observed that measures derogating from the provisions of the International Covenant on Civil and Political Rights must be of an exceptional and temporary nature, the court's case law has never, to date, explicitly incorporated the requirement that the emergency be temporary, although the question of proportionality of the response may be linked to the duration of the emergency. Indeed, the cases cited above relating to the security situation in Northern Ireland demonstrate that it is possible for an emergency within the meaning of Article 15 to continue for many years. The court does not consider that the derogating measures put in place in the immediate aftermath of the Al-Qaeda attacks in the United States of America and reviewed on an annual basis by Parliament can be said to be invalid on the grounds that they were not temporary. It should also be noted that history and the data also shows a ratcheting effect for these emergency powers, where powers used to address one situation are considered inadequate to deal with some new threat, leading to more and more repressive and draconian laws being introduced in response to each new emergency. Now, states of emergency have also typically and traditionally been used to stifle dissent and maintain repressive conditions. There is a strong link between the use of derogations and human rights violations. Again, this is not confined exclusively to tin pot dictatorships around the world, but also applies in the context of developed democratic states. The UK, for example, declared states of emergency in a number of its colonies as they faced uprisings against colonial rule, for example in Malaya, Kenya, Cyprus, British Guyana and Aden. Now, according to a public inquiry from 1972, in each area, UK state agents used the so-called 5 techniques during interrogations of insurgents. The methods included hooding prisoners, placing them in stress positions, subjecting them to sleep deprivation, and other actions. The techniques were found to amount to torture by the European Commission on Human Rights, and in the case of Ireland versus the UK, and inhuman treatment by the European Court of Human Rights in the same case. Now, the Parker Report from 1972 concluded that some or all of the techniques have played an important part in counterinsurgency operations in Malaya, Kenya, Cyprus, British Guyana, Aden, and Northern Ireland. And all of this was facilitated by the adoption of emergency laws which allowed suspects to be detained incommunicado and without trial. So we can see a very clear correlation between the existence of derogations and the perpetration of human rights violations across multiple jurisdictions. Now, these measures should be subject to supervision, which is where the element of things being required by the exigencies of the situation comes into play. When the state adopts emergency measures, they must be strictly required by the demands of the situation. In other words, they must be an appropriate means of dealing with the emergency. They must be required by the situation and not go beyond what is necessary to deal with the situation. Now, there are a lot of factors to take into account here. Firstly, as we mentioned previously, whether ordinary laws would have been sufficient to meet the danger caused by the public emergency. Secondly, whether the measures are a genuine response to an emergency situation. So here, avoiding the states using an emergency as an excuse to adopt extremely harsh measures is important. In the A and others case, discussed earlier, for example, the measures adopted were ruled invalid in part because they did not tackle the issue of international terrorism. The measures were supposed to be used for people suspected of posing a threat to UK national security, but it allowed these people to leave the UK to wherever they wanted to go as long as they didn't stay in the UK. This was essentially using an immigration measure to deal with a security problem. It did not seem to be a rational, genuine response to the emergency and was considered invalid. Another factor to consider is whether the measures were used for the purpose for which they were granted. So in this sense, we must question, are the measures meant to address the problem, or are they simply a means of repression? The other factors to consider are whether the derogation is limited in scope and the reasons advanced to support it. Many emergency measures will include sunset clauses, for example, that they are only allowed to be implemented for a limited period of time. The absence of a time limitation might indicate that this is not a temporary emergency measure, but a longer-term means of repression, and therefore not required by the exigencies of the situation. The courts will also consider whether the need for the derogation was kept under review, again emphasizing the need for this to be temporary. The final 4 factors that the courts will look at are whether there has been any attenuation in the measures imposed. So if the measures are changed over time, it shows they are responsive to changes in the nature of the emergency, particularly if measures are gradually relaxed as the emergency situation abates. This will indicate that the state is responding to the emergency, and it will likely mean that they will be considered more akin to the exigencies of the situation. The other thing to consider is whether the measures are subject to any safeguards. This will normally require some levels of oversight, in particular the availability of judicial supervision. This will also be impacted by the practicability of judicial supervision. So judicial review might be available in theory for the measures, but all of the courts might be closed as a result of the emergency, making it impossible. The court also takes into account the importance of the right at stake, and the more important the right, the closer the scrutiny of whether limiting it is necessary. And finally, the proportionality of the measure will be taken into account, whether they involved any unjustifiable discrimination, for example. Emergency measures, as we have seen historically, can often result in discrimination against minorities. Historically, we have seen discrimination arising in the context of derogations against Catholics in Northern Ireland, Kurds in Turkey, and Muslims in the UK. In fact, again, in the case of A and others, the measures adopted were considered to be a disproportionate response to the threat of terrorism, as the measures focused exclusively on non-nationals. It meant that they did not address the threat from nationals suspected of involvement with international terrorism, and they were therefore not required by the exigencies of the situation. The final consideration is whether the measures were lawful and had been effected in accordance with a procedure prescribed by law. The next issue to consider is that of notification. As we mentioned, states are required to notify the relevant authorities of their derogations. And we can see some differences in practice here between the ICCPR and the European Convention on Human Rights. The ICCPR demands that states immediately inform the other state parties via the Secretary General of the United Nations of derogating measures and specify which measures of the ICCPR they have derogated from. By contrast, the European Convention's requirements are much less stringent. States are required to notify without delay, a term which has been abused somewhat by states. States have been quite slow to notify the Council of Europe of derogating measures in practice. Analysis of the derogations reveals several instances of delayed, even retrospective notifications of derogations to the Council of Europe. In one particularly egregious example, the Isle of Man implemented the Terrorism Act of 1990, which necessitated derogation from Article 5 on the 1st of December 1990. However, the UK did not notify the Council of Europe of this derogation until the 13th of November 1998, almost 8 years later. In fact, when we look at the data, 40% of the derogations that the Council of Europe have received have not been notified to them until over 100 days had elapsed since their adoption. As van der Sloot suggests, the notification requirement is seldom, if ever, discussed in the court's case law and has lost most, if not all, of its importance in the most recent decisions. The second key differentiating factor is that there are no clear guidelines on what information must be communicated in the context of a derogation. In the Greek case, the European Commission observed that Article 15.3 does not oblige the government concerned to indicate expressly the articles of the Convention from which it is derogating. In practice, states indicate the content of the measures adopted, and this can be used to infer the derogation. This has led to states issuing some very vague derogations. The French derogation in 2015, for example, stated that the decrees issued by the French government may involve a derogation from the obligations under the Convention, without any further detail on the specific articles from which they were derogating. As Mariniello argues, this gives the executive arms of government a huge discretionary authority in the limitation of fundamental rights. Now finally, we'll finish off by looking at non-derogable rights. It should be noted that not all rights in international law are amenable to derogation, and there are some rights from which derogation is not permitted under any circumstances. The European Convention on Human Rights sets out the narrowest set of non-derogable rights: the principle of non-retroactivity, the prohibition on slavery, and the prohibition on torture, contained in Articles 3, 4, and 7. Other treaties include a much wider variety of rights in the non-derogable category. So if we look, for example, at Article 27 of the American Convention on Human Rights, which covers a range of other rights, it includes the right to judicial personality, freedom of conscience and religion, the rights of the family, the right to a name, the rights of the child, and the right to participate in government. However, in reality, the differences between the actual content of the derogation clauses is probably negligible in practice. A few examples can be offered here. So we see, for example, that there are differences in how different treaties are drafted that impact on the derogation clauses. We can see that the right to life is a non-derogable right in both the ICCPR and the American Convention on Human Rights, and appears to be better protected from derogation in those treaties than the European Convention. Under the European Convention on Human Rights, a limited derogation from the right to life is permitted. It states no derogation from Article 2, the right to life, except in respect of debts resulting from lawful acts of war, or Articles 3, 4, and 7 made under this provision. Now, in reality, the differences between each of the treaties in this regard is negligible because of the way the right to life clause is drafted in the ICCPR and the American Convention. These treaties protect against arbitrary deprivations of life rather than listing each of the circumstances in which life can be deprived, as the European Convention on Human Rights does. So in reality, deprivations of life that were consistent with the laws of war would generally not be considered arbitrary for the purposes of the International Covenant on Civil and Political Rights and the American Convention on Human Rights. This means that the scope of the right in each case is almost identical. We should also note that other parts of the derogation clauses cause overlaps in protection. So all parties of the European Convention on Human Rights are also parties to the International Covenant on Civil and Political Rights, and the derogation clause from the ICCPR then effectively extends to limit derogations from the European Convention. This is because one of the conditions of a derogation from the European Convention is that the derogations are not inconsistent with other obligations under international law. This means that if a state party to the European Convention derogated from a right which was derogable under the European Convention, but not derogable under the International Covenant on Civil and Political Rights, it would not be consistent with the state's legal obligations under the ICCPR, and would therefore be an invalid derogation from the European Convention. So in practice, the differences between the clauses on non-derogable rights is actually negligible. Now this brings us to the end of the first part of the lecture, and we'll pick up the second part shortly.